As Matthew said, I'm the General Manager of Southpac Group. We're based in New Zealand, but the majority of our business is done through our sister office in the Cook Islands. And I'm here today representing Cook Islands Finance with Tony and Tine from Asia City, from the Cooks as well. And it's my privilege to be here today presenting on the benefits of this wonderful jurisdiction. So, starting off with the Cook Islands now, based on conversations today, I've got the impression that many people don't know much about the Cook Islands or where it is, so here's a quick starter. So it's about 6 hours south from Hawaii. It would be about an 8-hour flight from Los Angeles, if you could get a direct flight from Los Angeles to the Cook Islands, and about 4 hours from New Zealand in terms of flight time. In terms of accessibility, though, with the time difference, it actually aligns quite well with the US. So depending on the time of year, you're about 2 to 3 hours behind Pacific time in the Cook Islands and 5 to 6 hours behind Eastern time. Where it gets interesting is the time difference with New Zealand, which is over the other side of the date line. So it's a 4-hour flight, but a 23-hour time difference. So you leave New Zealand and you get there 19 hours earlier. So the Cook Islands financial services industry has been operating for over 40 years now, so it's a very mature financial jurisdiction. It's got legislation across trusts, companies and foundations, and the first legislation enacted in the international arena was the International Companies Act back in 1982, and since then the jurisdiction has gone from strength to strength. The Cook Islands International Trusts Act, which is seen as its sort of flagship legislation, and which I'll be talking about in a little more detail shortly, is 40 years old this year, enacted in 1984. And the Cook Islands is a very well-established jurisdiction. It's got political stability, it's got its own elected government, albeit that it's in free association with New Zealand. It is not controlled by New Zealand. It has its own politicians, sets its own laws, and exists in a different relationship with New Zealand. It borrows judiciary from New Zealand to hear higher level court cases, for example, and those cases are based on the English common law. It's an English language jurisdiction, safe and stable. It's also very well regulated. And when I say well regulated, I mean as stringently regulated as it needs to be. There's a great common sense approach, and there's a lot of communication between the key stakeholders who work within the industry. The 8 trustee companies that are in the Cook Islands are members of a trustee companies association. That body has frequent contact with the regulator in the Cook Islands, and also frequent contact with representatives of government, so that everyone can be singing from the same hymn sheet and working towards the same purpose there to safeguard the jurisdiction and to deliver what clients need while ensuring that international regulations are complied with. And as you see there, internationally compliant, it's FATCA compliant and CRS, and is not on any international blacklists. But at the same time, is a relatively free jurisdiction. It's escaped some of the worst interference from organisations such as the EU. So there are currently no central beneficial ownership registers, let alone publicly accessible ones. And there are no economic substance laws at present in the Cook Islands, so there's a lot of flexibility still around there. Now, within those 8 trustee companies that I mentioned, there is an enormous body of experience, and some of that experience goes back to the 1980s when the Cook Islands was developing its asset protection, developing as an asset protection jurisdiction, and developing the International Trusts Act to become what is now widely seen as the gold standard in asset protection jurisdictions worldwide. And properly administering trusts under that act takes experience, it takes expertise, and that's something I'll circle back onto in a few minutes. But in the Cook Islands, you really do have this depth and strength and breadth of experience and expertise that helps you trust your asset protection trust partners and the companies delivering these products. So just to go into a little more detail on the Cook Islands Asset Protection Trust and how it works. Asset Protection Trust is a label. It's a trust like any other trust. The title Asset Protection isn't a legal title, but it's what a lot of clients set up trusts there for. Not the only reasons. I'll go into some more in a moment. But the reason it works so well as an asset protection jurisdiction is because the International Trust Act is drafted very protectively. So one of the prime examples of this is that assets that are placed into a Cook Islands trust by a person who, before anyone has a cause of action, before anyone has a reason to sue you, those assets are going to be protected from any future unknown creditor. So it's a very high level of protection that you can gain. Even if there is someone with a reason to sue you when you set up a trust, once you settle the trust, they need to move very quickly to have any chance of accessing those assets. And there's a series of tests they need to pass. One is a time test. They need to bring proceedings in their home jurisdiction within 1 year, and they would need to bring proceedings in the Cook Islands within 2 years to try and persuade a court to break open that trust and make the assets accessible to them. But they're only going to be able to persuade a court to do that if they can show beyond reasonable doubt, so that's to the criminal standard of proof, that your principal objective in setting up that trust was to defraud that particular creditor. And they also need to prove that your setting up that trust did in fact make you insolvent and unable to pay that creditor. So if you've kept assets outside of the trust that could satisfy that creditor's claim, the trust is going to be safe. If the creditor can't prove that your principal intent was to defraud that particular creditor, the assets will be safe. And there's a body of case law going back decades that has upheld the protective features of Cook Islands trusts. Other advantages of the Cook Islands and the trust law is that it doesn't recognise foreign judgments. So in this creditor-settler scenario, it's not open for a creditor to obtain a judgment from a US court, say, where the US court expresses its opinion that assets were placed fraudulently into the trust. The Cook Islands won't recognise that if it's inconsistent with the trust laws. They have to come to the Cook Islands to bring that claim. Another benefit in the legislation is that it doesn't recognise forced heirship. So if you're a settler from a jurisdiction whose laws require that your assets pass to designated persons upon your death, and you want to have more testamentary freedom and leave your assets to other people that you would like to have them, setting up a Cook Islands trust can provide for this. The Cook Islands legislation makes clear that forced heirship provisions of other countries are overridden by the legislation. Another benefit of the Cook Islands is its strong privacy laws. Now, it's currently a criminal offence under the International Trust Act to divulge information surrounding a trust or its settlors or beneficiaries or assets or transactions without reasonable excuse or under lawful authority. So there's a firmly protective framework in place that supplements the protection that assets are provided with under the law. And also, in terms of allowing settlers power and flexibility, the Cook Islands legislation has reserved powers provision that enable this. So, for example, they specifically provide that a trust can still be valid if the settler is a beneficiary or if the settler is a protector, for example. Now, there is a little caveat on this, as the direction of travel in the case law over the last few years has been for courts to more closely look at how trusts are administered. So they will look at the role of the trustee versus, say, that of the settler. They will look at the relationship between the settler and the trustee, and they will look at how the settler treats the trust. And if the settler is effectively trying to cut the trustee out of the loop, or the trustee has no independence and is just viewed and just behaves as a rubber stamper for all settler decisions, that could cause problems for the validity of the trust. So it's important, for example, if you have a trust with an underlying company and you've settled that trust and you manage the company, don't just put assets into and pull them out of the company for your own benefit. Remember, there's a trustee in that structure, and increasingly the independence and the role of trustees needs to be recognised and acknowledged and acted upon for trusts to remain valid and do the job you set them up for, which is to protect your assets. This again circles back to the expertise available in the Cook Islands among the trustee companies, and the expertise of the experience of the practitioners there who understand how the law is developed and who are very set on managing trusts in the right way and ensuring that they're properly administered and that they will remain protective of their clients' assets as a result. Looking at other offshore asset protection options that Cook Islands legislation provides alongside the International Trusts Act, you've got the Cook Islands Limited Liability Company. This is good standalone protective LLC legislation. It's based very closely on that which exists in Nevis, if anyone's familiar with that. Very limited options for creditors seeking to claim assets from an LLC. They again need to bring proceedings in the Cook Islands. The only the only remedy available is a charging order over the assets. It doesn't provide a right to receive distributions. It doesn't provide a right to make membership decisions, and it expires after 5 years and is non-renewable. For clients from civil jurisdictions who are maybe unfamiliar with the trust concept or less comfortable with it, Cook Islands has foundation legislation in place, and this can allow very flexible foundations to be set up, which can have a single member foundation council making the foundation decisions. That can be the founder if need be, and there's a lot of flexibility built into the law, which also means that you can circumvent some of the fiduciary issues that can cause managing a trust to be a little problematic at times. Cook Islands also has international companies. As I mentioned, that was the first legislation provided for back in 1982. And they can be standalone companies. They can and often are be owned by trusts that will own a shareholding in the company. But another important use for them is as private trust companies. So if you're setting up a Cook Islands trust, the trustee, it must have at least one trustee that's a Cook Islands trustee. Now, that can either be a licensed Cook Islands trust company, or it can be a Cook Islands international company that acts as a private trust company and can do so for up to 3 trusts. Now, that international company can be owned and administered and directed from outside the Cook Islands. So if, for example, you are a family office or you're a trust and corporate services provider in another jurisdiction that wants to unlock the benefits of the Cook Islands without having a Cook Islands resident trustee sort of involved in those decisions, then that's an option that's open to you using that structure. Now, the last thing I want to talk about in this presentation is the Cook Islands International Relationship Property Trust. And this is a unique and innovative product that was developed based on law passed in 2021. And the thinking behind the IRPT is that rather than protecting assets from creditors or from governmental overreach or courts, it essentially protects assets from the settlers themselves, because it provides that when settlers in a relationship or who are married place assets into a trust together, those assets are ring-fenced, and in the event that the settlers separate or divorce later on, those assets stay within the trust. The separation or divorce does not have the effect of you closing down the trust and dissolving it and distributing out all the assets. Now, the motivation behind setting up the IRPT was so many practitioners over the years had come across examples where couples would place, for example, interest in a family company into trust that they wanted to develop further and leave and pass on to their children. Subsequently, the settlers divorce, and those company assets are carved up. The business is no more, and they often have to be sold at a fire sale price. And then they're gone. They're not there for the benefit of future generations, and this goes against the entire, the entire motivation the settlers had for setting up the trust in the first place. So the IRPT provides this protective framework in which after divorce or separation, effectively the trust is locked in. The trust agreement can't be amended without the approval of the Cook Islands High Court, and assets can't be divided or distributed out. Another example in which the IRPT might be useful is if the parents of a child A, say, not that enamoured with spouse B, even though child A might be, and they are worried that spouse B may, eventually divorce and claim a lot of the family assets that they want to pass down to child A. So they could pass the assets to child A, who could settle the relationship property trust. the terms of this trust could provide that income is provided to child A and spouse B during their marriage, but upon their divorce, only child A and the children of child A can benefit. Spouse B is effectively cut out of the loop and can't make any claim to the asset. So it adds this sort of prenup element to setting up a trust. As I say, it's not a setup that's replicated in any other jurisdiction. It's unique to the Cook Islands, and there's been a lot of talk about it and a lot of interest gathering over the last few years. So it's something we look forward to building up further within the jurisdiction. So that is the end of our whistle-stop tour on the Cook Islands Financial Services. As I say, very happy to be here this week with Tony Fair, the CEO of Cook Islands Finance, and with Tine Ponea from Asia City, Trust in the Cook Islands. And it's a privilege to be flying the flag for the Cook Islands, and it's been a pleasure speaking to you all. Thank you.